This is Zari Investments and Equity Trust Company as custodian, FBO Rice Capital Solo 401k plan. Whew, that's a fun one. Zari Investments and Equity Trust, we'll just call it Zari, versus William McMeans, Tracy McMeans, and the other occupants there on Monarch. So who do I have on behalf of the plaintiff, Zari?
Keith Wolfshall, Your Honor.
Oh, good morning again, sir. And do we have someone here first for William McMeans?
Yeah, Bill McMeans here.
Good morning, Mr. McMeans. Thank you.
Good morning.
How about for Tracy McMeans? Anyone specifically for her?
Tracy is unavailable.
Okay. That's fine, sir. All right, then, Mr. Wolfshall, tell me why this eviction is sought.
This is a post-foreclosure eviction for holding over.
Oh, holdover. All right. So rent's not an issue here.
No, Your Honor.
When was the notice to vacate?
That was on October 27th. 3 day, posted on the outside of the front door and mailed on the same day with a letter, important legal document on the envelope.
Oh, okay.
And addressed to the defendants at the address.
Good morning, Mr. McMahons. Thank you for, or Mr. McBeans, I'm so sorry. Thank you for being here today. Mr. Wolfshall said that this is a case for a holdover matter, and they're not seeking any type of, I'm sorry, moving my keyboard, shut my whole monitor. All right, so Mr. McMahon.
So I don't understand, I didn't understand what's the holdover question?
So Mr. McMahon's, Mr. Wolfshall told me that the reason they're seeking an eviction is for what's known as holdover, meaning that you had the right to tenancy that you may have had, and Ms. McMeans may have had, has come to its end, and the landlord has said you have overstayed the amount of time that you were allowed to be here. There's no obligation to pay rent, but you cannot remain, and that is why it's called a holdover. Typically, we see these when a lease has not been renewed and a party remains in the premises. That's essentially what they're saying, except there was no lease here. They're saying that your right was terminated. Mr. Wolfshall, was it terminated because of the foreclosure, or was Mr. McMeans renting from someone?
No, Your Honor, he was the prior owner of the property, and so now my client is entitled to possession.
All right. Mr. McMeans, how would you respond?
Well, here's the deal. We've lived here for 33 years. We started up a business, got behind a little bit of a dog ate my homework excuse, I realize. I have offered the client, the group owning this, a payment for, I've offered to rent it back. We're in the process of selling off some intellectual property involved in a company I started up in 2019. I've bought and paid for this house twice. I'm willing to do it a third time. I would like to, but I tried to engage them. I did send Mr. Wolfshall a email offering a payment for a $50,000 for a 3-month reprieve from this eviction scenario. I will have that in the bank by this Friday, November 21st. But as a guarantee, I've been contacted by multiple law firms wanting to recapture the $114,000 plus that his clients overpaid. Well, they paid to Travis County, but is owed back to me. I've offered to let him go recapture that or hold it in escrow in order to ensure that they got that payment, and then would like to engage them in a negotiation on what I've asked his clients, what do you want to make on the house, and I will pay you back.
All right. Well, Mr. McMeans, I appreciate all that. Unfortunately, none of that is a defense or a stopping of the eviction for a holdover. All right. If the property has been foreclosed, that does terminate the rights. The new owner has the right to then move forward. And because it's a foreclosure, there's a shortened amount of time that they have to go through it. So that was why I asked, did you have a lease or were you the original owner? Today it would be a judgment for the plaintiff, but it's a possession only judgment. So Mr. McMeans, the only financial obligation the court would put would be the amount of court cost, but you don't owe them anything beyond that. Certainly you can still contact them about trying to resolve it in some other way, but the eviction becomes final after 5 days if you or they don't appeal, or you'll otherwise quickly come to some type of an agreement. I do have to give you a chance though to appeal, as Mr. Wolfshall's client gets a chance to appeal.
What happens in the appeal?
If you appeal, I'll just very, very quickly, if you appeal, it goes to the county court of law. You would say either one of the 2 county court of law judges in Travis County, and essentially the exact same hearing happens, only it's a different judge, and it takes a little bit longer to get there, maybe another 2 or 3 weeks from today before you would have that court to hear the case.
And what are the 5 days? You explained it, and you said it was 5 calendar days, but then you said it's 5 business days. Is that
It's 5 calendar days. If the final day falls on a day of the holiday or a weekend or a day we're not open, you get until the next business day.
okay? So that would mean the 25th of November for today. Would that be correct?
I am not allowed to confirm that, Mr. McMeans. They have absolutely told judges that that is considered advice, and I have to instead give you that weird 5 days. And then I know people love this is where you see laughter. Mr. McMeans, to verify the date, call any of those legal aid services that we highlighted and
Okay.
say, help me calculate my deadline, and they can do it. We're hamstrung. It's a weird rule. Okay.
All right.
Your Honor.
Those
And
are
then-
good questions.
And then to appeal, obviously you have a process on there. Like I said, we're going to have funds. I can go hire an attorney, but is there a way to get this appeal done sooner by just going through? Is there a easy to follow process on your webpage?
Certainly. And well, whether it's easy to follow, I won't make any judge about that. That's ask everyone, they have a different version. But we do provide you step-by-step instructions for both parties if you want to appeal, what to do and where to go and how to begin that. And essentially, you contact the court within 5 days. You file a notice of appeal, you pay the appeal bond, which we have to determine. And then this is not a non-payment matter. So once the appeal bond is taken care of, it moves to county court. County court then gives you a court date. You'll do the same thing again with them. And then, you can do anything you like in between that time period.
Okay, thank you
So
very
we will
much.
say- No, I like that, Mr. Means. We're going to give you good instructions. We do that for both sides. All right, I need to set an appeal bond for y'all though. Mr. Wolfshaw, do you have any sense of what the mortgage was for the property?
Your Honor, my client paid $665,000 for this property. We would ask that to be set at, or the appeal bond to be set at 2%. I calculated that as 13,300.
This is a single family home?
Yes, ma'am. It's in an exclusive community, gated, in a very well-off neighborhood. And well, I would also just mention the court, because my client wants me to mention this, that the city and the HOA have been hounding my client about getting this property rehabbed. So we would add, I know that's neither here nor there for the appeal bond, but we would ask that the court take that into consideration.
I understand. I'm going to say something to you, Mr. Wolfshaw, that might be a consideration. If you want a $13,000 bond, it's my experience, or just my impression, that very high bonds are very easy to appeal with an affidavit of inability, because can't nobody come up with 13 grand if you've been foreclosed on. You still want a $13,000
I understand, but he
appeal
just,
bond?
I understand, Your Honor, my client wanted to bring that up, but he also has $114,000 waiting with the county.
All right, Mr. McMeans, do you have any things that you'd like to say as to an appeal bond for this? What was your
Well,
mortgage
Yeah,
prior?
the 14,000 with the county, I literally have no idea how to go get that.
I'm not worried about escrow money with the county. Zero concern. I'm asking Mr. McMeans, what was your mortgage prior to foreclosure?
It was it was like 2978 was the payment. It was a home equity loan.
Oh, okay. So it actually you weren't paying for the home. The home is paid and this was just paying back the home equity loan?
That is correct.
Ah. Tell you what, I'm gonna make both of you a little bit unhappy. I'm gonna double what he says he was paying for the escrow, and that's gonna be half of what you wanted, Mr. Wolfshaw. I'm gonna put down $6,000 as an appeal bond, and I think that's reasonable and sufficient for both parties to protect you both. All right.
Thank you, Your Honor.
All right. Good luck, everyone. Thank you very much, Mr. McMeans. Thank you for coming today. Mr. Wolfshaw, you said you had 4, so I think you probably have one more with me.
I have 2 more, Your Honor.
2 more.
Yes.
All right. Well, then, Mr. McMeans, you're all excused and have a good day, sir. Have a better day. Thank you. Agave at South Congress versus Leroy Bryant, and others. Who do I have on behalf of Agave? Anyone here on behalf of Agave?
Oh, sorry, I muted myself. I'm here, Your Honor. Anna Ham for the plaintiff.
Good morning, Ms. Ham.
Good morning.
And are you counsel?
Yes, Your Honor, I'm with Rogers Law Firm.
Okay, good morning. Well, I saw Rogers Law Firm, so that's why I double checked. All right. And do we have anyone here on behalf of Laura Leo Bryant? Roche, do we have anyone check in for these defendants, Bryant and Bryant?
Your Honor, we should be getting into the defaults. However, I do see someone called in with a 452 number, so I'm not sure if that's a defendant or not.
That's right. If you're here on the proceedings and your phone number ends 452, if you'll press *6 and unmute and just identify yourself, I want to make sure we get you checked in. We don't want to skip you or not give you a chance to be heard for your hearing. So if you are here and you're listening and your calling on your phone and your phone ends in a 452, please press *6 to unmute. All right, well, we'll give them a minute. If they jump in, we'll check them out. Otherwise, Ms. Ham, we're going to proceed. I'm going to pull up service to the two defendants, and why don't you give me the information about why the case is being sought?
So this was originally an eviction based upon conduct, but however, we are now seeking eviction on the basis of the non-payment of rent. The monthly rent is $1,449 a month. There's been a failure to pay since October 1st of 2025. Due to the default, a 3-day notice was posted onto the exterior of the door and was mailed on October 8th of 2025. We are now seeking back due rent for October and a prorated November for a total amount of $2,318.40.
All right, was there any subsidy on the 1449?
No, Your Honor.
Is this a CARES property?
No, Your Honor.
All right. You said that. I'm out of curiosity, what were the lease violations?
So there were several, Your Honor. One back in September was September 13th. Leroy specifically attempted to harm staff and prospective residents while they were on a tour of the apartment. He had a weapon and they had to barricade themselves inside of the unit, and the police were called. Do you want to hear the other ones?
No, that's
okay.
I typically we just hear non-payment, so
Okay.
I got a little morbid curiosity as the judge, like what are some of the other types of things that we get? All right,
I get you.
we received back the return of service for both of the defendants. So this first one is for Leroy Bryant. I'm highlighting his name here for cause 25-1483. Service was affected to that defendant. It was done alternate service. They attached to the front door and a copy was mailed, and that was done by Deputy Gamboa with Constable Precinct 3's office. The second return is for co-defendant Laura Lee Bryant. This is also 25-1483. In a similar vein, Deputy Gamboa attached to the front door and mailed a copy, and that was effected on October 20th. So sufficient time has been here for parties to respond. All right. And Ms. Ham, in addition to rent and cost of court, are you seeking anything for your time today?
Yes, Your Honor, I am.
How much are you taking for attorney's fees?
So I would like to say that because this first started as a conduct, it is a little bit higher than I normally ask. So I am asking for $1,600 in attorney's fees, Your Honor.
What is that based on?
That is based on, so my time is $230 an hour, and my colleague's time is $300 an hour. We have spent approximately 6 hours on this case, either connecting with the client, going over video footage, going over criminal records, etc., as well as doing the petition for this specific eviction process. It is submitted to the court under Exhibit P5.
Fantastic. I see that. Thank you, Ms. Ham.
Of course.
Oh, everything was good. Got the original petition, got plaintiff's notices and exhibits, and we did receive the military affidavit, a sworn statement from you that through your research you were able to determine it is your belief that neither Laura Lee Bryant or Leroy Bryant are actively deployed in the military. All right.
Yes, Your Honor.
Judgment for the plaintiff, $2,318 plus cost of court, as well as $1,600 in attorney's fees. For appeal, it's October and November. I would double the rent and make the appeal bond $28.98.
Yes, Your Honor. Thank you.
And that is for the non-payment. And I indicated other lease violations, but for non-payment is what you've actually asked it to be under today. And so that's what we'll mark it for. All right.
Thank you.
Do you have other matters today?
I do. I have one for Amley Covered Bridge.
Okay, let's see. We just work them down as y'all get them brought in. So the next one then is, Ms. Ham, you're going to stay with us, but if we'd had other parties to that matter for 1483 are excused. And so now we are with 25-1539. This is going back to Agave at South Congress versus No, this is probably gonna be Ms. Ham. This is Agave at South Congress doing business as Agave at South Congress versus Edgardo Garibolini and other occupants. Ms. Ham, are you here for this matter?
No, Your Honor, that's me this morning.
Oh,
Keith Upshaw.
is this the same complex?
I'm not 100% sure.
Oh,
We
not
were a little
100%
confused this
sure,
morning
Your
on it.
Honor.
Or I
Yes,
was at least.
yes, Your Honor, it is.
Oh,
Okay.
okay, just because y'all got two kind of different stylings. One's doing business as and one's,
Yep.
don't we all love business formations? Isn't that the
Absolutely.
run-on that goes? Okay. All right. Well, Mr. Wolfshall, thank you. You're here for this one. Do we have any one of our defendants? Do I have Edgardo Garibolini or any occupants to that property? No. All right, Mr. Wolfshall, why don't you give me the information? I'm going to pull up service to the defendant.
Yes, Your Honor. This lease started on April 29th, 2025 at a rental rate of $1,143 per month. That rent is not subsidized by any government agency. The lease is currently due for the September, October, and November payments. The 30-day notice to vacate was given on 9/8/2025, and that was by first-class mail. And we're seeking possession of the property, the back rent of $2,971, which is what I prorated through today, plus court cost. We're not seeking attorney's fees.
All right. And was it 30 days because it is a CARES property, or was that just landlord
Oh.
chose to go?
Yes, Your Honor, 30 days cares, I believe.
Okay. Sometimes it is, sometimes it's not. If you did it 30 days, it counts no matter what. All right.
Yeah, they didn't indicate to me whether it is a CARES property, so I'm going to assume it is since they gave it 30.
Seems reasonable. All right, here's the return of service. So this is for cause 25-1539 for Edgardo Garibolini. And I can see that Rule 510 Deputy Hobbs with Precinct 3 did affect alternate service, put it on the door and mailed it the same day. And that was October 29th. All right. And 1143, is that what I heard for rent?
Yes, ma'am, 1143.
All right. Judgment for the, oh wait, one more thing. I got a military affidavit. Yep, looks good on the
Yes.
military affidavit. Not on active duty. All right. Judgment for the plaintiff, $2,973 plus your cost of court. For appeal, I would double it because it's September through now. So that would put the appeal bond at $22.86. That's twice the monthly rent.
Thank you, Your Honor.
Thank you. And then all parties to that are excused. That's AAHC South Park doing business as the Bridge at South Park Meadows versus Laura Milla and others on behalf of the Bridge at South Park.
Keith Wolfshall again, Your Honor.
And then anyone on behalf of Laura Miller or other occupants. Again, if you're here and you're listening and you're in the phone number ending 452, you need to unmute and announce present. If you're unable to, if you believe you're speaking and you're unmuted and we're not hearing you, you can disconnect and call the main court phone number and tell them who you are. And that will at least let my clerk know and we can try to assist you that way. But if you don't unmute, we won't know who that is. All right, Mr. Wolfshall, I'm going to go ahead and pull up service for the defendant, Mr. Miller, or Mrs. Miller, and why don't you give me the information related to this matter?
Yes, Your Honor. This lease began December 12th, 2024 for a one-year term that ends on December 11th, 2025. The rental rate for this term is $1,494 per month. The lease is currently due for the August and all subsequent payments. A 30-day notice to vacate, presumably under the CARES Act, was given on September the 9th, 2025. As I said, that was a 30-day, and the defendants are still in the property. We did file the military affidavit along with our petition, showing that he's not in the military. And we're just asking for possession, the back rent of $4,679 plus court costs.
Said $4,679.
Yes, Your Honor. That's what I calculated through today.
Okay. I do see the return of service, rather, I'm looking at the notice to vacate here. I can see that was done first class mail, and the return to court was actually served in person. So here is that return. For notice of today's lawsuit and of the hearing, service was provided to the defendant, Laura Miller, for cause 25-1540, and it was done in person, hand delivered directly to the defendant by Deputy Hobbs with Precinct Constable, or Deputy Constable in Precinct 3. So the defendant did know of the hearing, or at least is aware of the situation. Okay. And then we got a military affidavit. I see that one. Let's just open that up. A CRA actually gave me the military printout straight from the Department of Defense. All right, military affidavit is fine, not deployed. Judgment for the plaintiff, $4,679 plus your cost of court. For appeal, it is since August.
Yes, Your Honor.
I'm just gonna double it. Anything more than that, we get into different kind of issues. So I think for reasonableness to both parties, I'm gonna put it at $29.88.
Yes,
That's
Your Honor.
right.
Thank you.
All right. Anything else today, sir?
No, sir, that's my last case before the court. May I be excused?
Thank you. Yes, you are. Have a good day.
You have a good rest of the day. I'm sorry about my audio.
Oh, it happens. Thank you. You
Thank you.
did a good job. You kept working with it.
Thank you.
All right. Then we are with 25-15-53. Emily Covered Bridge versus Zachary Week, Anna Guanlo, and others.
Anna Ham for the plaintiff, Your Honor.
Good morning.
Good morning.
All right, do we have anyone here on behalf of Zachary White or Dana Guanlo? We've not had anyone check in. All right. Why don't you tell me why this eviction is being sought, and I'll pull up service to the defendants.
Of course. So we're here for an eviction based on the non-payment of rent. The monthly rent is $1,479. The 3-day notice to vacate was hand-delivered to the defendants on October 8th of 2025, and to our knowledge, the defendant has yet to vacate. We are requesting back due rent for October and a prorated November for a total amount of $2,366.40. We are also seeking possession of the lease premises, court costs, and attorney's fees in the amount of $750, Your Honor.
All right. And not a CARES Act property, a 3-day notice, hand-delivered. We did receive back the return for both of the defendants. Yeah. Here's the first one. This one is for Miss Guanlo. Dana Guanlo, or actually maybe Guanlo, for cause 25-15-53, in-person service from Deputy Caldwell with Precinct 3. And for the second one, to Mr. Zachary White, they left it with Miss Guanlo there at their property, and so that was the service for that co-defendant for cause 25-15-33. So defense service to both parties did occur. Receive plaintiff's exhibits, including their information about court cost, or I'm sorry, about your attorney's fees. Thank you, Ms. Ham. And then
Of course.
also we got the military status affidavit. You've checked. These parties are not deployed. Okay. Judgment for the plaintiff, $2,366 plus your cost will also include $750 for attorney's fees. And then on appeal, I'll double it. I can work a calculator. It'll be $29.58. Actually, Ms. Ham, I'm going to leave that at just 1 month of rent, $14.79. I typically don't like it to be higher than the judgment. Sometimes there's factors into it, but that I'll feel better. $14.79.
Okay, thank you, Your Honor.
You're very welcome. And Ms. Ham, any other matters?
No, Your Honor, may it be dismissed.
Yes, you are. You're all excused. Have a good morning. Thank you.
Thank you, you too.
And then we will be with 25-1545. Avalon Hill Country versus Thomas Morton and others. On behalf of Avalon.
Hey there, Sydney Smith, present for Avalon Hill Country.
Good morning, Ms. Smith. Thank you. Very, very patient with us today. I appreciate it.
Of course.
Do I have anyone here on behalf of the defendant, Thomas Morton? No, nothing. All right. Ms. Smith, if you'll tell me why this eviction sought, I'll pull up the documents and take a look.
The eviction is sought for non-payment of rent. It is not subsidized. The monthly base rent is $1,320, and it is unpaid for October and November. I calculated the prorated amount for November to be $792 for a total of $2112 due.
Okay. And is this a CARES property?
It is not.
And when and how did y'all give notice to vacate?
The notice to vacate was delivered on October 8th, and it was affixed to the inside of the main entry door.
Okay. We did receive a military affidavit as well, straight depart out from the Department of Defense that Mr. Morton is not currently deployed. And we received the return of service from the constable's office affecting notice of this hearing and of the eviction filing to the defendant, 25-1545 for Thomas Morton. It was served Rule 510. Deputy Caldwell attached it to the front door and mailed a copy as well. All right. Judgment for the plaintiff, $2,112 in back rent plus cost of court. And then on appeal, we'll put that at 1 month of rent. That'll be $13.20. All right, thank you. Ms. Smith, do you have other matters today?
I do not.
Thank you very much. Then you're all excused. We appreciate it. Have a nice morning.
Sure.